Welcome to the ACE Your RES Exam Key Topic Deep Dive series. Today we're tackling a really fundamental topic for the RES exam, but one that can be tricky. Encumbrances on property title here in Singapore. Think of encumbrances like, well, uninvited guests crashing your property title party. They just show up, stake a claim, and suddenly that complete control you thought you had. Yeah, it's restricted. So our mission today is to cut through all that legal jargon, really nail down the definitions you need, break down the main types, financial and non-financial, and crucially, flag the key bits from the Land Titles Act, the LTA, that you absolutely have to know for the exam.
That's a great way to put it because, honestly, for anyone aiming to be an RES professional,
Hmm.
getting your head around these limitations is just, well, it's essential. You needed to prove good title to a buyer.
Yeah.
An encumbrance, basically, is some kind of third-party claim or right over a property. It limits what the owner can do, affects selling it, using it, the whole package. And the big takeaway, really, for you listening, these burdens, they usually stick with the property when it's sold. They transfer right along with it.
Okay, so before we meet these uninvited guests properly, let's quickly set the scene. What's the legal foundation here, the stage they're crashing?
Right. So the big picture context is the Torrens system of land registration we use in Singapore. The whole point of this system is certainty. You look at the register, you trust what it says. The person registered as the owner, the proprietor, their title is considered paramount. Indefeasible is the legal term. It means you hold the land free from all encumbrances.
But there's always a but, isn't there?
Exactly. There's the crucial exception, the reason we're doing this deep dive. You hold it free from all encumbrances except for the ones that are actually registered or noted down in the land register.
Right.
That exception, it's right there in the Land Titles Act, Section 46, subsection 1. And that's why understanding these registered burdens is so critical. If it's on the register, it chips away at that paramount title.
Got it. Okay, let's start meeting the guests. First up, the ones after your wallet. The financial encumbrances. Debt-related stuff. Mortgages seem like the obvious starting point.
Absolutely. The mortgage is probably the most common financial encumbrance everyone knows. It's simply a loan, and the property itself is the security, the collateral for that loan. It's that classic debt burden. The property isn't truly free and clear or unencumbered until that mortgage debt is fully paid off and the mortgage is discharged from the register.
And registration is key here, right? What if the bank, say, forgets or delays registering it with the SLA? What happens then?
Well, they're not completely sunk, but their position is definitely weaker. To be fully effectual, as the LTA puts it, that mortgage must be registered with the Singapore Land Authority's Land Titles Registry. Priority between different claims, like maybe multiple mortgages or mortgage and a charge, is decided by the date of registration. So if you don't register, you risk losing out to someone who registered later, but before you. Once it's all paid off, discharged from the register, then the property is unencumbered, free from that specific claim, and potentially others like liens, caveats, CPF charges if those were also cleared.
Okay, now for something a bit more RES exam specific. The difference between a mortgage and a charge. They both secure debt, but they're not quite the same thing legally, are they?
They're not. Good point. A charge is also a security tool under the LTA. But the defining thing about a charge is that it's an equitable encumbrance. What that means is it basically earmarks the property for the debt. It gives the creditor a right to look to that property if the debt isn't paid. But, and this is the key difference, a charge doesn't transfer legal ownership or possession to the creditor.
Okay. Can we simplify that? What does equitable encumbrance and no transfer of ownership mean in practice for, say, the property owner?
Yeah, let's break it down. The main practical difference is about control and title. With a charge, the owner keeps the legal title, stays in possession. But the creditor still has a legal hold over the asset. If the owner defaults on the debt, the creditor has a legal pathway they can apply to the court to force a sale of the property to get their money back. It gives them security without actually taking over the property.
Right, so it's a way to secure the debt without the full complexity of transferring title back and forth. Makes sense. Now, what about claims from the government? Statutory liens.
Yep, statutory liens. These are financial claims, too, usually from government bodies or statutory boards. Think unpaid property taxes, maybe outstanding charges for estate upgrading, things like that. These claims get attached directly to the land title itself and stay there until the debt is settled.
This brings up a really specific point I know trips people up in the exam. Construction contractors.
Okay.
If a builder does work and doesn't get paid, can they just slap a lien on the property itself?
Yes. Critical distinction needed here for the exam. The general rule under common law for immovable property, the land and building, is no. A contractor doesn't have a general right to put a lien on the property just because they haven't been paid. There is an exception, but it's very specific. It comes from the Building and Construction Industry Security of Payment Act. Under that act, if a contractor gets a formal adjudication determination saying they're owed money, they might get a statutory right to a lien, but only over unfixed goods related to the project, not the land or building itself.
Okay, that's a super important distinction. Immovable property versus unfixed goods. Got it. All right, we've dealt with the money grabbers. Now let's talk about the other kind of uninvited guests, the ones who want to control how you use your land. Non-financial encumbrances. Let's start with easements.
Easements. Yeah, these are interesting. They're often described as rights that are sort of parasitic on the land. It's where one property owner, the dominant owner, gets a specific right over someone else's land, the servient land. Think of a classic right-of-way to walk or drive across a neighbor's plot to get to your own, or maybe the right to run pipes or wires underground.
Yeah.
It's a formal legal interest in the land recognized under the LTA.
And there are different types we need to know, right? Different flavors of easement.
That's right. Three main ones to keep in mind. First, the affirmative easement. This lets someone do something on the neighbor's land, like the utility company running a gas line or pedestrians using a footpath. Second, the negative easement. This one is different. It allows the easement owner to stop the neighbor from doing something on their own land, maybe stopping them building something that blocks light or air based on an agreement. And third, there's the easement in gross. This one is distinct because it benefits a person or a company like maybe Singtel or SP Group personally, not because they own an adjacent piece of land. Crucially, if that person moves or the company ceases to need it, the easement usually ends. It doesn't automatically pass on. Big difference.
Now, historically, getting rid of an easement, even one that wasn't needed anymore, was apparently a nightmare. Is that right? Like they could stick around forever.
Oh, absolutely. That was a major issue. Courts recognized them as really hard to extinguish. Once granted, they were pretty much seen as permanent. If the owner benefiting from the easement, the dominant owner, just refused to give it up, even if it was totally obsolete, the owner of the burdened land was stuck.
Imagine trying to redevelop a site in land-scarce Singapore, but being blocked by some ancient, unused right-of-way. Sounds incredibly frustrating.
Exactly. It could completely stall development. A very unsatisfactory situation, especially here.
But then, and this is key exam stuff, the law changed things significantly.
Yes, a major turning point. Section 105A of the Land Titles Act. This came into effect back in August 2014. What Section 105A does is give the court the power to modify or even completely extinguish an easement. The condition is that the court has to be satisfied that because of changes in the land's use or character, the easement continuing basically just gets in the way of developing the burdened land reasonably without providing any real practical benefits anymore to the person who holds the easement. There's a great example, actually. Imagine an old property had an easement for a specific C-shaped driveway across a neighbor's land. But then years later, a new public road gets built right alongside the property, giving direct access. That C-shaped driveway, totally redundant now.
Right, nobody needs it.
Exactly. But under the old law, if the neighbor with the easement right just dug their heels in, maybe out of spite, you couldn't force them to release it. Section 105 provides that mechanism now. It allows the court to step in and say, look, this easement serves no practical purpose anymore, and it's hindering development. Let's remove it. It helps balance property rights with the need for efficient land use.
That's a really important update to know. Okay, two other quick non-financial restrictions. Caveats and leases. What's the deal with those?
Caveats are basically warning flags lodged with the Land Titles Registry. Think of it as someone shouting, hey world, I have an interest in this property. Usually it's lodged by a buyer after signing the option to purchase, or maybe by a bank providing a loan. What it does is it effectively freezes the title. The property generally can't be sold or mortgaged further without notifying the person who lodged the caveater. They usually last for 5 years, though they can be extended.
So it's a protective measure? And a lease. Why is that considered an encumbrance? The owner still owns the property.
They do own the title, yes.
Yeah.
But think about it. If you own a property, but there's a tenant with a valid lease for, say, the next 3 years, your rights as owner are significantly restricted, aren't they?
Yeah, you can't just move in or kick them out or redevelop the place.
Precisely. You can't occupy it. You can't easily sell it with vacant possession. Your usage is heavily constrained by the terms of that lease. So even though you hold the title, the lease encumbers your full rights and usage of the property until it expires. That's why it counts.
Okay, that makes sense. So we've covered the types. Let's bring it back to the practical side for the RES professional or someone studying for the exam. What does all this mean day to day?
It really boils down to one thing: due diligence. Thorough, rigorous checking of the property's title before any transaction happens. You absolutely cannot just rely on what the seller tells you.
You need the official record.
You need the official record. And the primary tool for that in Singapore is the SLA's Integrated Land Information Service, or UNLIS. That's where you, as a professional, pull the title search, check for registered mortgages, caveats, easements, everything. And actually, it's become even easier for owners themselves now. Since around 2016, SLA launched the My Property Online service. Property owners can log in via SingPass and view their own title deeds, boundary plans, and see documents for encumbrances like mortgages or caveats, usually for free.
Wow, okay. So really no excuse for anyone involved not to know what's officially registered against the property.
Pretty much. The information is accessible.
Now, speaking of real-world stuff and financial planning,
Oh,
we absolutely have to talk about decoupling. It's a hot topic, often linked to managing stamp duty, especially ABSD. How do encumbrances play into this?
right. Decoupling. It's a strategy where typically spouses who co-own a property arrange for one spouse to transfer their share to the other. The spouse who transfers their share out, the outgoing owner, then essentially becomes a first-time buyer in the eyes of the rules, allowing them to buy another residential property without paying the additional buyer's stamp duty, or at least paying a much lower rate.
Okay, sounds like a neat financial maneuver, but there's a catch related to encumbrances, isn't there? Something crucial for the exam.
There's this, and this is a very important point. If that transfer of the share between the co-owners is done by way of a gift, meaning no money changes hands for the share, it's just given this is only legally possible if the property is completely unencumbered.
Oh, okay. Unencumbered means.
It means there must be absolutely no outstanding mortgage loan secured against the property and no outstanding CPF charge on it either. Zero financial claims registered. If there is an outstanding mortgage or CPF charge, you can still decouple, but it usually has to be structured as a sale and purchase, not a gift. Funds must be available to pay off the outgoing owner's share of the loan and refund their CPF used, plus interest. It complicates things and involves actual cash changing hands.
So the gift route, the potentially simpler route, hinges entirely on the property being free and clear of those financial encumbrances.
Exactly. And the examples sometimes cited, like the Pam family saving something like $98,400 in stamp duties through decoupling, that just highlights why understanding and managing encumbrances is so central to property-related financial planning in Singapore. It has real dollars and cents impact.
Wow. Okay, this has been a fantastic tour through the world of encumbrances, from the basic rule of paramount title to all these exceptions and limitations.
Yeah, so just to quickly recap the main buckets. Financial encumbrances, think mortgages, charges, and remember that specific rule about contractor liens. Then the non-financial ones, easements, and the crucial Section 105A update, caveats, and leases. Getting these concepts clear is really foundational for advising clients properly and, of course, for proving good title in a transaction.
Definitely. And maybe one final thought to leave you with, something to chew on as you hit the books for the exam. We talked a lot about the registered owner's title being paramount, indefeasible, but even that powerful principle isn't absolute. There's always an exception, right?
Always. The biggest one that can potentially overturn a registered title is fraud, as defined under the Land Titles Act.
And fraud here isn't just lying or cheating in the normal sense, is it? It's broader.
That's right. While it definitely includes actual dishonesty, the courts have interpreted fraud under the LTA to cover what's called any species of equitable fraud.
Okay, equitable fraud. What does that actually mean in simple terms? You mentioned something like a resulting trust.
Yeah, so think of a situation, maybe, where someone contributed significantly to the purchase price of a property, creating what's called a resulting trust. They have a beneficial interest, but for some reason, their name wasn't put on the legal title register. If the registered owner knows about this legitimate claim, this trust, and then dishonestly tries to deny it or sell the property out from under the person with the beneficial interest, that can be considered equitable fraud. Basically, the law says you can't use the shield of being the registered owner to improperly defeat someone else's known legitimate proprietary interest in the property. It's about preventing the registration system itself from being used as an instrument of injustice.
Fascinating. So even the bedrock principle has its limits when fairness and equity demand it. Okay, master these encumbrance concepts, understand the nuances like Section 105A and the decoupling rules, and you'll be in great shape. That's all the time we have for this deep dive. Really hope this helps you ace that section of the exam. Good luck with your upcoming RES exam.